Welcome to the Virtual Center for the Study of the Constitution of the United States. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He's also your host for this program. And here he is, Dr. Bill O'Brien.
Welcome to the Virtual Center for the Study of the U.S. Constitution. I am Bill O'Brien, and we have reached midweek. It is a Wednesday on a gorgeous summer day here in West Virginia, and I hope that the weather is equally gorgeous where you are as well. I know that we are having some weather issues in the Midwest, and of course, like everybody else, I hope that that nothing terrible happens, even though the potential for tornado activity is there. It seems like more and more that's happening all the time, but we'll just have to hope that folks in that area can deal with it, and that the weather won't be anything like experienced in Moore, Oklahoma, a couple of weeks ago. Welcome to today's program. I really am appreciative of the time that you have chosen to give to our program today or any day. I take that decision on your part to donate some of your valuable time to our program as a very, very serious responsibility on our part to do the best we can to make that investment of your valuable time worthwhile for you. Recognizing, of course, that if it's not, then you obviously are free to go elsewhere or to use your time in other ways that you feel will be more productive. I welcome you to the program. I basically encourage you to participate actively in it. We give you a phone number and hope that you will use it. The number is area code 304-658-3333. That's area code 304-658-3333. My personal email address is waobrien906@gmail.com. That's waobrien906, all one word, no spaces or punctuation at all. waobrien906@gmail.com. Going to get a little bit of tutoring sometime toward the end of the week over this coming weekend, with the idea that some of you may be much more comfortable during the program itself to drop an email to me rather than call on the phone, and that would give me the opportunity to tune into your email directly and respond to it in a timely fashion, which is when you decided to send it. And you know, I want to open that availability as well. I want our program to be as interactive as possible. And granted, I have some skill limitations. I don't chat or Twitter back and forth as rapidly and as smoothly as many people do. I don't type. That was not one of the skills that I learned, and I guess I feel like I'm maybe a little bit old to learn now. But anyway, so I don't want to get into a back and forth while I'm on the air and while I'm trying to formulate logical positions on issues while we're on the air and everybody's listening to. I really am not going to be able to engage in an interactive back and forth with you. But if you had a comment that you would like to drop on an email, I'd be more than happy to receive it and to entertain it and get it on the air for you right at the time that you sent it. And I think that would probably be a lot more beneficial and a lot more meaningful to folks tuned in. It would improve the interactive nature of the program itself, make it a little bit more interactive than it has been. But right now, I'm kind of dependent on hearing from you. So if you do choose to pick up the phone and give us a call, please do that. We would love to get you on the air, and I'm sure our listeners would be happy to hear your point of view as well. Again, I think that the very nature of the very fact that you are tuned into this program or to the Head On network itself says an awful lot about you and an awful lot about the quality and the capability of what folks would like to hear. I think that there, if there is a screening mechanism in place here, it is the fact that the very fact that you listen basically says a lot about you, and that means that your ideas and your thoughts and your willingness to share them is something that all of us will benefit from. And so I invite you to do that as well. Yesterday, at the very end of the program, as you recall, we were dealing with a decision of the Marshall Court in 1823 called Johnson versus McIntosh, in which Marshall incorporated into American legal jurisprudence the so-called idea of the doctrine of discovery, something that was originally cast in the late 15th century by the Pope in his effort to try to avoid conflict between the newly formed nations of Portugal and Spain by arbitrarily dividing the world between them so that they would not engage in conflict over control of colonial areas of territories. And thus came about the so-called, and very textbook used to emphasize this all the time, the very famous line of demarcation, which essentially divided the world between the Roman Catholic, the Catholic nations of Spain and Portugal. And it's very, very significant, I think, that England was not even party to that action, yet John Marshall feels very comfortable in tapping into that as a justification for the right of colonists, of settlers, to seize control of land from so-called aborigines, those who are not availing themselves of the greatest use of that land. It almost smacks, I was thinking after we went off the air yesterday, it almost smacks of something related to the idea of manifest destiny, which becomes very, very fashionable in the late 1840s in the United States as a justification for the war with Mexico, from out of which, as you know, the United States gained control over former Mexican territories in Arizona, New Mexico, and California, and a lot of the southwestern part of the United States as a result of that war. And the rationale of the justification for America's right to take territory from Mexico was based not so much on the doctrine of discovery, which Marshall cited in 1823 in the Johnson versus McIntosh case, but from the idea of usage, that there was a rationale which became part of the whole justification for going to war with Mexico over this disputed territory. The justification was the idea that those who would make the best use of the land obviously had the most right to it. And this was part of the whole manifest destiny rationalization that is appearing in the media during this time in order to justify America's right to go to war over the disputed territory and to take territory from another nation, in this case Mexico. And the assumption was, of course, that the Mexican culture was not conducive to the usage of the land that Scripture had intended that man make use of the territory of the land that God gave us. So the assumption is that God created the world and he gave it to man for his usage. And the rationale, the logical extension of that kind of thinking was that those people who would make those cultures or those civilizations which would make the most use of it had a right to it. And that became part of the manifest destiny idea, which justified not only the Mexican War at mid-century, but later on, justified America's expansion overseas during the so-called Spanish-American War, with the seizure of Hawaii and the Philippines and Guam and many of the islands in the Pacific that had previously, before that war, belonged to Spain. And it indicates a rationalization or a justification for an action, which obviously is nationalistic and self-interested from the get-go. There's no question that Marshall's use of the doctrine of discovery in 1823 in order to justify the idea of Christians to take land from so-called aborigines, in this case Native Americans, in upper New York State, because they would make better use of it, is the same kind of principle. And what it suggests is the interpretive nature of law. And again, I go back to a comment that I had made several weeks ago, and I believe in it firmly, and I don't want to overemphasize it because I don't want it misinterpreted. But the traditional idea in the minds of many people that law is something abstract and neutral is something that I think all of us need to rethink. Law, by definition, is usually an action taken by certain people to regulate or control the actions of other people. It usually has an agenda associated with it. There are going to be, with every piece of legislation ever passed anywhere, there usually is going to be a winner and a loser in the particular, according to the particular issue under discussion and the law that's being passed. And in this particular case, the losers were going to be the Indians in upper New York State, and the winners were going to be those who sought territory for their own self-interest. And so basically what we see is an effort to try to come up with justification or reasons why people felt in their own minds it was okay to take this land because we would make better use of it than the people who had it. And some people found that to be much more consistent with Scripture, and on and on and on. And I think it's very significant that John Marshall buries within this 1823 decision of Johnston versus McIntosh, establishes the legal precedent for the so-called doctrine of discovery, which basically makes it possible later on to go back and cite it as a principle of American jurisprudence because it had been used in a previous Supreme Court decision. I think that's very interesting. But if it does anything, it tends to downgrade or raise serious questions about the idea of the neutrality of law. The assumption is that because we are a nation of laws, because we operate around the concept of the principle of the rule of law, and our whole republic is based on the idea that none of us are above the law. All of us are required, no matter who we are, all of us are required to obey the law and to live under the law. And in fact, the law should not treat certain of us differently than other people. We all ought to be treated the same, treated equally under the law. That's what the principle of rule of law is, and that's the legal basis on which the American public is founded and developed. Based on that, I wanted to go back a little bit. I mentioned yesterday during the program, in fact, yesterday's program was pretty much a response to a number of emails that I received over the past weekend on programs and issues that we were dealing with. And I want to express my gratitude to those of you who took the time to send those emails. And I wanted to specifically make reference to one which I didn't have time to get to yesterday, but it's so appropriate because it fits exactly into the issues we were just talking about the idea of rule of law and people being treated equally under the law. And it gets into the Constitution of the United States and the whole idea of the so-called Privileges and Immunities Clause of the 14th Amendment. And the assumption is that under the principle of rule of law, nobody ought to be treated differently than other people under the law. All of us are required as citizens to obey the law, and by definition, the law must treat all of us equally and fairly, and ought not to give specific benefits to certain people at the expense of other people. And the idea of the Privileges and Immunities Clause becomes the basis later on for a number of Supreme Court decisions based on, as part of the civil rights movement in the late 19th and early 20th century, as former slaves, black Americans, are struggling in order to be treated as equal citizens under the rule of law in this society. And this particular email relates to a particular situation going on currently in Texas. And this is taken from the Dallas News. This is an article that appeared in the Dallas News. The date is May 27th, and of course today is May 29th, so this is just 2 days old. And it basically relates to a piece of legislation that is wending its way through the Texas legislature right now, the state of Texas, about the issue of gun privileges. Specifically, a bill was being debated in Texas that would penalize cities and counties for prohibiting guns from public facilities where they were otherwise permitted. As we know, Texas is kind of out in the forefront of the idea of gun rights, and that's what this is related to. And so the legislature was debating a bill which would penalize certain citizens or certain counties if they tried to prohibit gun access in public facilities where these privileges were permitted. To that particular piece of legislation, which was under debate in Texas, was added a provision, an amendment, which would grant members of the Texas legislature the right to lift restrictions on concealed carry permits in order to protect themselves. In other words, an amendment was added to this legislation which would give members of the Texas legislature special provisions that would allow them to carry a concealed weapon anywhere within the state of Texas. And that particular amendment stopped the legislation, the principal legislation, in its tracks. A Republican member of the Texas legislature named Kenneth Sheets responded to that amendment by saying, when I was sent here to take care of my constituents, not to advance my own self-interests. Another Republican member of the Texas legislature, Jonathan Strickland, supported the original bill, which basically forbade counties and cities from limiting gun access where it was otherwise prohibited. But Strickland acknowledged that he switched his position because of the addition of the new provision. He said, "I'm very sad that we took a bill that I supported and did this to it." At issue, of course, what caused the controversy was an effort by Ryan Guillen, Guillen, Democrat of Texas, who sponsored the bill, to believe that members of the legislature needed special protection under the concealed carry provisions of Texas legislation. When this was added to the bill, the legislature voted against the bill 103 to 38. In other words, this amendment on special carry privileges for members of the legislature caused the initial bill to go down to defeat. The sponsors of the legislation, Guillen and others, argued that members of the Texas legislature needed special gun provisions or privileges because they regularly receive death threats. And one of the Republican members of the legislature, Representative Van Taylor, argued, "I'm surprised to hear that so many people on this floor have received death threats. I thought it was just me, but it's widespread." And so the basic issue came down to special privileges for members of the legislature that other citizens of Texas didn't have. The reality is, and this is mentioned at the close of the article, but it's something that I wanted to emphasize as well, even if this bill had passed, even if the bill with the amendment had passed and not been defeated, it probably would have been struck down had it been challenged, had it been moved to a higher court, because it violates the 14th Amendment, which gives citizens equal protections under the laws. What legislators were doing in this amendment was to be giving themselves special privileges that other citizens were denied. And this is clearly a violation of the equal protection provisions of the 14th Amendment. And that's really the issue. The point that I'm making is we were just talking about the idea of rule of law and the idea that everybody is entitled to be treated the same under the law. That's what the principle of rule of law is. None of us ought to get privileges that others of us are denied. And that's clearly what Texas was beginning to do here. And, of course, I guess I have to basically reveal my own prejudices here by saying, if so many members of the legislature are getting death threats, then there's absolutely no question that giving them special privileges under the concealed permit laws in Texas is one approach to it. Of course, one could argue, and this is me talking, and I acknowledge this to be the case, that maybe the reason so many of them are getting death threats is because what they're doing is so damn stupid. I don't necessarily like to say that, but the fact of the matter is maybe what I believe to be the total insanity of this effort of arming everybody in a civilized society is being brought to the fore here. Maybe that's the issue. But be that as it may, right now, our focus is on the issue of equal protection or no special privileges and immunities under the law if we are to remain a nation that is governed by the principle of rule of law. And I think this is a classic example of it. This particular article appeared in the Dallas News just 2 days ago on the 27th of May. And I think it's very significant because it kind of suggests that this idea of giving certain people special privileges under the law is not something that only applied to the 19th century. It's something that continues to be with us all around us, and it's something that we need, it seems to me, to consider. It is clearly a constitutional issue, the 14th Amendment Equal Protection Clause, as well as the Special Privileges and Immunities Clause, which denies that some people ought to be treated differently than other people. In this society, the mere fact that you are a citizen in this society entitles everybody to have essentially the same constitutional protections. Where this issue, and I'm kind of expanding on this point before we move on to another issue, but I think it's significant. Where this whole issue really becomes controversial, it seems to me, is when we look at it from the perspective of those who are not citizens of this society, who are visitors to our nation, who are immigrants from other societies who have not applied for and been granted citizenship. And then the question is, do the protections, do the special privileges and immunities under our Constitution apply to everybody who lives here, or do they only apply to those who are citizens of the United States? And this, of course, relates to the issue, the controversial issue that's out there now about the use of drones on American citizens, which you'll recall several weeks ago, a member of Al-Qaeda who was a United States citizen was taken out in a drone strike. There's also the question of illegal immigrants to the society, and whether in fact we have a responsibility to treat people the same, whether in fact they are citizens of the United States or not. In other words, does the issue of citizenship take precedence over people's humanity, the fact that people are human beings and as such have a right to be treated a certain way? If we believe that under the rule of law in this society, all citizens ought to be treated equally because they have a right to be, is it because they are citizens or is it because they are human beings? And the fact that we are, as a civilized society, are trying to say to the world that we treat all human beings with respect and honor. And it doesn't matter, in effect, whether they're citizens or not. Now, granted, citizens obviously would have direct access to our legal system and our court systems and the rest of it. But the fact of the matter is, in terms of the way we treat each other as fellow human beings, it raises serious questions. And I think President Obama has raised this issue once again when he raises the issue of closing Guantanamo, where we have people down there where we don't have evidence that they did anything that warrants their incarceration, but there they are, they're sitting there, they have not been able to avail themselves of the constitutional protections granted to citizens of the United States to face their accuser, and the right to have a jury trial, and the right to an attorney, and the right to a speedy trial, and the right to be judged as much as possible by a jury of your peers, and all these other things. All of these privileges, if you will, are being denied to those that are incarcerated in Guantanamo. And President Obama has raised the issue, and I think it's a very serious one, holding these people without charges conceivably forever and not transferring it into regular jails and conceding the rights that we grant all other citizens who are incarcerated raises serious questions, because President Obama, as a constitutional lawyer, believes that this violates everything that we are about as a nation. It tends to contradict the first principles on which the founders created this nation, that all men are created equal and endowed by their Creator with certain inalienable rights, and that among these are the rights to life, liberty, and property, and that these rights cannot be taken away without due process of law. Again, does the war on terror, is it so unique and so special in the history of the world that it justifies denying certain human beings rights that we as a society commit to treating all giving all human beings? I think the issue is a serious one. I think President Obama has put his finger on something that is very, very significant. We talk all the time when we talk about the founding about the inconsistency of the condoning of slavery in the Constitution of the United States as being a violation of the principles of the Declaration of Independence. And if we really were, as a society, as a republic, if we really are committed to the principles laid down in the Declaration of Independence, then how could we justify that and at the same time condone slavery as we do in our Constitution? And of course, we have some very famous pieces of literature in American society. Thoreau's criticism of that, his refusal to pay taxes to support the Constitution of the United States because of its willingness to condone slavery. We have a number of examples of this. And so the question is, as we go through our history, one of the things that constantly keeps coming up is the extent to which we as a people are confronted over and over again with the reality between what we say we stand for and what we indeed do stand for. It seems to me that is an important issue. It is an important question. It's one that our nation should consistently confront throughout its history. It raises questions, for example, about the doctrine of discovery that we talked about. Does it seem even feasible that John Marshall would go all the way back to a papal bull issued for Catholic nations in the 15th century, which didn't even apply to England, and yet John Marshall would go back there in order to pull out something that, for purposes of his time and place, which was 1823 in the United States, it seemed that that doctrine became particularly appropriate for a particular reason or for a particular end or goal or objective that Marshall had, which is to basically embed the idea of the doctrine of discovery with legal precedent in our legal system. Seems to me very, very significant. Anyway, I wanted to get to that email because one of our listeners was kind enough to send it to me about the Texas issue, and I think this particular email and others as well are sending me things that they think may be appropriate for our program and that we might want to introduce and be able to introduce on future programs. And I want to do that as much as we can. I want to basically acknowledge the contributions of those people who are listening to the program and who are doing everything they can do to contribute to the depth and the understanding and appreciation of the goals of the program. That's what the Virtual Center for the Study of the Constitution is all about. It's community education and outreach more than anything else. What we are talking about is educating the citizenry at large on the current contemporary applications of the Constitution and interpretations of the Constitution throughout the history of the nation as reflected in major Supreme Court decisions. And, of course, we began, as one obviously would, by focusing on the court under Chief Justice John Marshall, because so much of America's legal precedent, so much of the outlines of the power of the federal government and the relationship between federal power and state power, which becomes so critical in our system of federalism, divided sovereignty between states and the central government, seems to me so much of it is embedded in court decisions over the years that there's no way in the world you can conduct an examination of the meanings of the Constitution without looking at the way the Supreme Court has taken on specific aspects of that Constitution. We did it a few weeks ago when we looked seriously at the Contract Clause. We looked at two major cases of the Marshall Court, namely McCulloch versus Maryland in 1819 and the Dartmouth College versus Woodward case also in 1819. My point was that there's much more to those decisions than merely the content of the cases themselves. And I'm kind of laying the background here. I'd like to get into a little bit today about another clause of the Constitution that becomes a critical one for the Supreme Court over the years, and that's the very famous Commerce Clause. What we talked about with McCulloch versus Maryland and the Dartmouth College case in 1819 is that while the McCulloch versus Maryland case seemed to revolve principally around the constitutionality of the United States Bank, and while the Dartmouth College case focused principally on the idea of sanctity of contract, the idea Marshall Court ruled that the original charter which created Dartmouth College as an independent private educational institution was, according to Marshall, a contract, and thereby had, the college had the right to expect that contract would not be violated by government. And so when the state of New Hampshire tried to take over a private college and convert it into a public college, it, according to Marshall in Dartmouth College, violated the sanctity of the original contract which created the institution. And so McCulloch focuses around the constitutionality of the bank. Dartmouth College focuses around the sanctity of contract. I would suggest to you, and that was the reason we spent so much time on those two cases, I would suggest to you that those cases also raised issues about the nature of corporations in American society, more specifically about the right of government to create corporations in order to fulfill its constitutional responsibilities to promote the public interest. That it is very clear in both of those cases that the Bank of the United States and Dartmouth College, while one's a bank and the other one is an educational institution, they are both corporations created by government for specific purposes of promoting the public interest. And as such, Marshall felt the need to elaborate in both decisions on the nature of corporations and their importance to government in order for government to fulfill its constitutional obligations to promote the general interest, the general welfare. Or as I like to use the term, the public interest. And so the implication here is incredible. Because what Marshall is suggesting is that government power means that government itself has the right to define the public interest. The public interest is not abstract. Neither is the public interest fixed in time. What Marshall is basically suggesting is that over time, the definition of the public interest changes. And as that change occurs, so also must government's ability to change with it. The powers that government must have in order to promote the public interest must change as the definition of the public interest itself changes. This becomes, I believe, the basis for the idea of the living Constitution. The idea that in order for a Constitution to remain relevant, it must be able to address positively the issue of change. As the public interest changes from generation to generation, from decade to decade, from situation to situation, so also must government's ability to define the public interest and to focus on that change and address it positively and constructively. That, I would argue, is the real basis of the need for the living Constitution. Otherwise, if you lock the Constitution into the very period in which it was written, there's no way in the world that it could remain relevant unless you amend it and re-amend it and re-amend it and re-amend it, which is what Madison's concern was. That's what states governments did under the Confederation. The state constitutions became so long and so laborious and so internally contradictory and inconsistent as members of state legislatures were trying to remain relevant that it became impossible for the average citizen to even know what the law is or how the law today is different from what it was yesterday. Madison's position was, and Marshall's position was, in McCulloch versus Maryland and in Dartmouth College, that if you look at constitutions that way, they cease to be constitutions and they become codes of laws instead. Marshall's position is a constitution must remain stable. It must be internally consistent but flexible enough to adjust to changing circumstances. And what Marshall is doing in his most famous court decisions is filling in the blanks on the Constitution of the United States, which the founders, in their wisdom, created to be flexible and variable and in the right places, vague and open to interpretation and reinterpretation. The alternative is change after change after change, amendment after amendment after amendment. And what Marshall said in these decisions was, if you approach government constitutions that way, they become more codes of laws and cease to be constitutions. Constitutions are much more limited. Constitutions, by definition, in order to win the support of their people, must be short enough that people can know and understand what they are. Government must have the responsibility and the flexibility to update constitutions by changing the definition of the public interest as it changes, as public needs change. Government must be able to keep up. And I think that's very significant. Marshall is basically suggesting that government's right to create corporations and to give them their head, give them independence from government, from too much government control, is, according to John Marshall, a key feature of what government's responsibility to define the public interest is all about. He said that clearly in McCulloch. He said it again equally as clearly in Dartmouth College versus Woodward. And what Marshall, I believe, is doing is laying the groundwork for what we call today the living Constitution. Most of those who support the idea of a living Constitution focus their attention principally on Amendment 9 in the Bill of Rights. And I'm reaching for my copy of the Bill of Rights as I speak, and I'm not sure I have it in my hand. I can't believe I was able to put my hand on it. But Amendment 9 says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So if the Constitution specifically addresses certain rights that citizens, that the people will have, that doesn't necessarily mean that there won't be others added as the situation calls for them. Those who would defend the idea of a living Constitution tend to point to Amendment 9 in the Bill of Rights as the strongest proof for the idea of a living Constitution, for a legal precedent for the idea that the founders believed that the Constitution would change as society's needs changed, as definitions of the public interest changed. And so I think that issue, I think we pretty well, I believe, we did a fairly good job with that issue. It's the best job I can do. It's what makes sense to me. I am not an attorney, but I have read a number of Supreme Court decisions over the years, and I really believe that more than anything else, this is what we're really talking about here. We are talking about the idea of the public interest and the idea that public interest changes as society moves from generation to generation. And in order to be relevant, government must be able to keep up with those changes if it is to carry out its constitutional responsibility to promote the general welfare, which is in the preamble to the Constitution. We are almost at 45 minutes after our first hour. We have exhausted a goodly portion of our first hour together. And I mentioned earlier that I'd like to spend some time today going into another area of the Constitution that the Marshall Court focused on, which is the very famous Commerce Clause. The Commerce Clause is located in the Constitution in Article 1, Section 8, Paragraph 3. And in that, if you remember, Section 8 of the Constitution is that section in which Congress is given specific delegated powers. The power to lay and collect taxes, the power to do this, the power to do that. That was Section 8. The third one gives Congress the power to regulate commerce between the United States and foreign nations, between the United States and Indians and Native Americans as nations. I think this is an important issue which I think we will address in some future program. There's absolutely no question. I think probably he doesn't get the credit, the historical credit that he deserves, but Henry Knox is probably more responsible than anybody during this period for recognizing the fact that these Native American tribes, these American Indians, are independent nations, and as such fall under the international provisions of our Constitution when dealing with them. And so consequently, treaties that the United States makes with Indian nations, according to Knox, fall under the provision as the supreme law of the land, because they are international treaties that our government undertook to negotiate with sovereign nations. And so the implication is that these Native American tribes are, for constitutional purposes, foreign nations, sovereign nations. And as such, agreements, contracts made with them fall under the Commerce Clause, which gives Congress the power to regulate commerce between our nation and foreign nations, between our nation and American Indians, and this is the key part, I think, between commerce between states that make up our union, between one state and the other. The issue here, I mean, this is pretty basic, but I want to make sure I say it, because sometimes when you speak rapidly, this is lost in the translation. There is a major difference between interstate commerce and intrastate commerce. INTRA versus INTER. Interstate commerce is commerce that happens between two or more states. Intrastate commerce is commerce that happens within the confines, within the borders of an existing state. The courts have made it very clear over the years that Congress's commerce power, Congress's power, delegated power to regulate interstate commerce, does not extend to intrastate commerce. The federal government does not have the right to go into the state of West Virginia or New York or Pennsylvania or California or anywhere else and tell the state government of that state what it must do or not do in relationship to business that is happening solely within the state itself. That is the state government's function. And so, in a sense, by giving Congress the power over interstate commerce, it does not give Congress the power over intrastate commerce. And that's a very, very important distinction. And so there is a whole series of decisions as Congress is expanding the commerce power. And very obviously, one of the issues is the definition of commerce itself. Is commerce merely trade? In the first major decision that the Marshall Court makes related to the Commerce Clause, the case of Gibbons versus Ogden in 1824, Marshall addresses the definition of commerce as part of the Commerce Clause, which is, again, Article 1, Section 8, Paragraph 3 of the Constitution. And Marshall defines commerce as intercourse. In other words, he is not willing to limit the power over interstate commerce to merely trade. By defining commerce as intercourse, what he is basically doing is talking about the wide variety of interactions and interrelationships between the United States and other nations, between the United States and Indian tribes, or between individual states within the United States itself. That, it seems to me, is very important. What Marshall does is create the broadest possible interpretation of the idea of commerce by defining it as intercourse. And basically what he therefore is doing is opening up the interpretive possibilities for the federal government, for Congress, of using its power to regulate interstate commerce as a way to regulate a number of facets of the internal operations of this country. Whenever relations with a state crosses that border and enters into the relations of into another state, it ceases to be the prerogative of either state and becomes the prerogative of the federal government under the Commerce Clause of the Constitution. So over the years, depending on the inclination of Congress, Congress has been able to use the Commerce Clause to intervene directly into a number of different issues. For example, does Congress have the authority to intervene in any way in the manufacture of an item? Later in its history, the Supreme Court uses the Commerce Clause to make the point that if a particular item that is manufactured within a state becomes involved in interstate commerce, in other words, if that item is going to be sold outside the state, within another country or within another state, Congress automatically assumes some aspect of control over its manufacture because it is a product which every expectation is will find its way into interstate commerce. And as such, it falls under the banner, if you will, under the umbrella of the Federal Commerce Clause. Over the years, the federal government has been able to use the Commerce Clause to regulate interstate transportation in cigarettes, alcohol, prostitution, stolen vehicles, and any number of other issues which have become issues of interstate commerce under the Commerce Clause. Therefore, Congress has assumed the right to make legislation, to pass laws affecting these items because of their presence in interstate commerce. Now, obviously, if you get a much more conservative Congress that seeks to minimize the powers of the federal government and limit the ability of the federal government to interfere in a variety of different ways related to the day-to-day operations of the nation's business, then the interpretation of the Commerce Clause is going to become much more narrow, much more focused, much less ambiguous. And depending on the makeup of the particular Supreme Court at that time, the court's interpretation of the Commerce Clause are going to follow with that kind of consistency. There's a very famous expression that the Supreme Court follows public opinion. The way the Supreme Court interprets the Constitution usually follows public opinion. The court's rulings, the court's view of the relationship between law and the people is that the reason Congress is given the authority to pass laws is because Congress is the most directly responsible to the will of the people. It's the branch of government closest to the people. It's the branch of government that makes law. And the assumption is that in order to be effective, law must reflect the will of the population, the will of the populace. Now, that has all sorts of ramifications in terms of interpretation, granted. But I think, again, going back to the expression, eventually the Supreme Court's interpretation of the Constitution will follow the ballot box. Depending on what the priorities of Congress are, that usually reflects the priorities of the public at large as reflected in the ballot box. And therefore, eventually, the will of Congress in carrying out the will of the people will affect the way the Constitution of the United States is interpreted by the Supreme Court. And it makes quite a bit of sense if you think about it. So it seems to me that in order to look at the nature of the Commerce Clause, we must look at John Marshall's decision in the case of Gibbons versus Ogden, which is a decision reached in 1824. It relates directly to the whole issue of interstate commerce, specifically the river traffic between the states of New York and New Hampshire, specifically the Hudson River, which forms the border between those two states. And so whatever happens on the Hudson River between New York and New Jersey obviously involves the whole issue of interstate commerce. And as such, would seem to fall logically under Congress's delegated power to regulate interstate commerce. But it's not until the Supreme Court speaks in 1824 in the case of Gibbons versus Ogden that that role for for Congress under the Commerce Clause is defined by the Supreme Court. And that's what Marshall is essentially doing, is re-emphasizing via interpretation of the Constitution, is emphasizing specific aspects of the Constitution as they grant power to the federal government to define the public interest. We have already looked at the Marshall Court in the contract decision of Dartmouth College versus Woodward, where the role of government is to essentially promote the sanctity and defend the sanctity of private contracts. That's why Dartmouth College won the decision in 1819 in the case of Dartmouth College versus Woodward. And in that case, Marshall makes very clear that the right of government to create corporations does not mean that government has the right to oversee or control or regulate those corporations. They are created as independent, free entities for purposes of promoting the public interest as government defines it at that particular point in time. We have reached the top of our first hour. Let's pause and take a 5-minute break if we can, and we'll stretch and get some liquid refreshment of one kind and another, and we'll come back and we'll take on our second hour. We'll look much more specifically at the case of Gibbons versus Ogden. I'm Bill O'Brien. This is the Virtual Center for the Study of the Constitution. You're listening to the Head On Radio Network. We'll be right back.